Please be seated, please seated. All right, we're back in session on Richard S. Gardner versus Volusia County and George Rechtenwald. I guess everyone got a chance to get a bite to eat, and Mr. King is not here. I was hoping he maybe perhaps didn't have any caffeine or sugar. All right. Welcome back, everyone. Where were we and where should we pick up? Anyone have any suggestions? Mr. McKinney?
Your Honor, I think, and I recall when we left, you had some questions, and I think when we left, the court was, the issue that we were addressing, I think the court was struggling with was I guess in paraphrasing, since the investigations of the dismissal, or notice of dismissal have been issued, what's the point, if you will? Or what, if you will, is the right for a compliance review committee? I think that's, and if it, in fact, is it a right that they have after the, if you will, the dismissal's been issued. I think that's what, as I understood the court's concerns when we left.
It is certainly a concern, yes.
And one of the things that we were discussing when we left, and I think that the county's position was, there were remedies, if you will, of this, call it this alleged wrongful investigation, could be resolved at a personnel board hearing, which is to be coming later as relation to Captain Gardner's employment. I remember. And you were asking them specifically, you know, can he assert all the same rights? And there was a discussion along those lines. But I'd like to go back and address that particular issue, and then go and talk why I had an opportunity to go back and review the statute and to discuss some of the language of the statute and see if I might be able to do a better job, I think, in explaining what I believe, why the statute allows.
Well, I'm going to be able to give everyone about 40 more minutes total, I hope, and maybe a little longer if I squeeze some things out. So we'll try to do the best we can, but if we can kind of keep that in mind, I'll have to reserve some time for the county. And again, please feel free to sit down unless you just prefer to stand up.
I prefer to stand up only as a matter of
that's fine.
Habit, and I apologize that is a little bit different in decorum. One of the opportunities I had, and we discussed it before we left, was a case that the parties brought up, the case of McQuaid versus the Department of Corrections. I remember, if you recall, Your Honor, there was discussions about what does that case say in relation to what we have here today. And in this particular case, Your Honor, I had the case in front of me. I think the citation was offered to Your Honor. The background of that case, it was very simple. A former state correctional officer had been dismissed from employment with the Department of Corrections and then filed career service appeal with the Public Employees Relation Commission, which, as I understand it, is synonymous to a personnel board hearing. You have your appeal, you've been dismissed, you get an appeal.
Well, they certainly share characteristics.
Correct. And what this court on footnote number 2 very clearly said, in this particular case, what happens, the officer actually brought, as being suggested here, brought the claimed violations in front of that employment commission, instead of bringing it to the circuit court, as we've done here today. On footnote 2, it says, dismissed state correctional officers only remedy for violations of the Department of Corrections of provisions of the Law Enforcement Bill of Rights requiring and this is out of actually subsection 532(6)A, is requiring an investigation of a correctional officer for an infraction within 180 days after the date of the agency receives notice of an allegation by a person authorized by that agency to initiate an investigation of misconduct.
Right, let me interrupt you for a second. That's kind of like or at least could be argued, some condition preceding to dismissing someone.
That's correct. It's part of the Policeman's Bill of Rights, and again, it's under section 112(532)(6)A. That's where that specific provision, which that particular correctional officer brought a claim for violation of the Policeman's Bill of Rights, goes on to say an investigation of misconduct was to apply for injunctive relief, this is his sole relief, with the circuit court, and thus Public Employees Relations Commission, to which the officer submitted career service appeal of his dismissal, lacked authority to provide officer any relief for DOC's alleged violation of the provision.
Right. I read that, and I agree with you that it certainly was an interesting holding, which actually doesn't resolve our case one way or the other, but I do think that we can learn some things from it. But let me just ask you about this, and then you can go on and discuss this case. Two things struck me about that, at least two things about the McQuaid case. Number one, the provision that they were addressing, and that the officer was, which the officer complained, involved, maybe not technically, but what we just agreed moments ago was a condition proceeding to being terminated. And I'm not sure that this 112.534 impaneling of a compliance review panel could be described as being a condition proceeding, or now it's 2-1. It's to stop a bad investigation from continuing. So that's one difference, I think. And then the other thing that struck me about McQuaid is they did say right at the conclusion of the majority opinion, I'll just read it, quote, because he did not seek an injunction from the circuit court before he was dismissed, or show prejudice in the proceedings before the commission resulting from the violation of the 180-day rule, he is not entitled to reinstatement on the basis of that violation. Here, close, close, close. So it seems to me they're saying, or at least suggesting, at the very least, that had he been able to show prejudice because of the lack of that 180 days provision, that he could have obtained relief properly before, I guess, the commission. So that would suggest to me that if your client were prejudiced by a bad investigation, or more to the point, a failure to appoint a compliance review panel to look into a bad investigation, again, using the very shorthand and precise language we've been using, if he could show prejudice from that, legal prejudice from that, then perhaps he likewise would be entitled to reinstatement on the basis of that violation. But that's not what you're seeking.
No, Your Honor, we're not seeking reinstatement, but, you know, again, with respect to the footnote, it says that the only remedy is through the circuit court. So I'm not sure how to couch that, the dicta there at the end, with the very clear holding that they put in the footnote saying that the only remedy is through the circuit court.
So the language right at the end of the opinion, not a holding, but this footnote that they stuck in is a holding, you think? Is that...
No, Your Honor, but I think it could be interpreted certainly that if he could show prejudice after dismissal, that would be an issue in front of the circuit court also. If it was an issue in front of the commission, it certainly could be an issue here with the circuit court. But one of the things that I also want to bring the court's attention, because what we've talked about here is what can't you resolve with the personnel board? Well, one of the things is, and we've talked about it, is yeah, we can argue to the personnel board that this investigation was unjust, as set out in the written documents. But that particular investigation goes on in Captain Gardner's record. It becomes, if you will, a mark and a representation as to his character as a law enforcement officer. He can't challenge the veracity of that in a personnel board. We can argue the personnel board it was done improperly, but this is his only opportunity. The Criminal Justice Standards and Training Commission, which is the department which oversees licensed law enforcement officers, take those into consideration when they are determining whether to have disciplinary action or renew licenses. So even if he doesn't get relief at the personnel board, if he wants to go anywhere else and be hired by anyone else and become productive as a law enforcement officer, this is his only opportunity to challenge the investigation. Not the dismissal, the investigation. That's why it's so critical that he have the opportunity to have that challenge. It may not change the outcome in this particular case, but it may change everything in regards to down the road.
Well, that may be an important interest that he has, or a concern that he has, but where do I read that in the statute, that this is the reason, raison d'etre for this the statutory scheme.
That's where I want to go to the stat. It says very specifically, it sets out violations that occur